35 in, yeah.
Highway challenged on the ground that it violates the basic
The
structure.
35A, it is, there are 5 petitions pending.
No, but that's before that it was never challenged.
They were challenged at the relevant point of time, could never be decided. I think
First bit 2014, then post.
since long. Lord, kindly see, my lord, the impact of this. The cutoff date was, my lord, I am told 1927. So whoever came in Jammu and Kashmir in 1927 were permanent.
That's the law. What is the provision itself? It says it not, the judicial scrutiny is therefore prevented because
Now, the impact was, for example, people from Jammu and Kashmir, people from Pak-occupied Jammu and Kashmir, Pak-occupied Kashmir, POK, were driven out, both Hindus and Muslims. But they were driven out in 47 during those raids. They are not permanent residents. They were not permanent residents till 2019. There were large number of Safai Karmacharis who have filed a petition, my lord, or intervention application, who were brought from other states to do, my lord, the manual work of cleanliness, etc. They are not permanent residents. They are not getting any of these benefits. Despite living for decades together, no person, my lord, beyond outside Jammu and Kashmir can acquire property, meaning thereby no investment.
From this point of view,
Yes.
I was just looking at the 1954 order, CO 48.
Yes.
That applied the entirety of Part 3
Yes.
and then made certain modifications. Therefore, Article 16 applied, Article 19 applied. But now see what happens. If you look at the CO, it applies Part 3. That is Volume 3. You get it at Volume 3, page
14 months.
page 14.
Yes.
Volume 3, page 14. But you bring in Article 350, Article 35A, which creates an exception in 3 areas. Employment under the state government, 2, acquisition of removable property, 3, settlement in the state, leave aside scholarships. So though Part 3 is made applicable, by the same vein, when you introduce Article 35A, you are taking away the 3 rights, 3 fundamental rights. 16(1), 19,
14.
and 16(1), then you are taking away the right to acquire removable property, which then was a fundamental right under 19(1)(f) and Article 31. And third, settlement in the state, which is a fundamental right under 19(1)(e).
Right.
So though the
Settle in
Constitution expressly made the provisions of Article 19 applicable, which would include these 3 rights, and Article 16, by enacting 35A, you virtually took away the fundamental rights.
Employment is also right to life.
Right, but there's a direct right under 16(1).
Yes. No, employment is a separate right and would fall within separate category of right to life.
No, that itself was not taken away. What was taken away was employment under the state government. Because what 35A did was, it says conferring on such permanent residents any special rights and privileges or imposing upon any other persons, any restrictions. So it does both things. You can give special rights to residents and you can take away that right insofar as non-residents are concerned. Employment under the state government. Employment under the state government is expressly covered by Article 16(1), because 16(1) says there shall be equality of opportunity for all
Yes,
citizens
yes,
in matters
your
relating
lordships
to
are right.
employment under the state. That includes the union as well as the states. So while on the one hand, Article 16(1) was preserved, 35A directly took away that fundamental right and granted immunity on to any challenge on the ground that it would deprive you of a fundamental right which is protected by 16. Likewise, 19. 19 recognizes the right to reside, settle in any part of the country.
Right to acquire property.
And
Then-
property then was 19.
Then now it is 300.
So all 3 fundamental rights were essentially taken away by 35A,
And
which
it
was brought in by CO 48.
It continued till 2019.
Power of judicial review was taken away.
Judicial review was taken. So it is beyond 9th schedule. Almost put at par, beyond 9th schedule also. And this continued till 2019, till the impugn resolution, impugn CO was passed. Therefore, my lord, I am respectfully urging that please look at the matter from the point of view of people of Jammu and Kashmir. Something which is impugned before your lordships is a constitutional exercise of power which confers fundamental rights, which applies the entire constitution, which brings the Jammu and Kashmir people at par with their rest of brothers and sisters, and Lord applies all laws which are welfare legislations, and I have the list which was not applicable to the state of Jammu and Kashmir. And the very unfortunate part is, and this is really, my lord, a troubling part, that till now the people were convinced by those, my lord, who were supposed to guide them, that this is not a hindrance in your progress. This is your privilege. You fight. Nobody can take away 370 from you. That is the most unfortunate part. And your lordships have, my lord, at least 2 major political, I'm not being political, major political parties before your lordships defending 370, including 35A. When your lordships ask, what did you lose out of it? There is no list. This is what the people rightly lost. They got their fundamental right 35A goes. They got their fundamental right 35C goes. And I will come to, my lord, several other, my lord, provisions which were working against the interest of the people, but they were convinced. Now they have realized what they have lost. Because now, because of 35A not being there, investments are coming. Now, because of, my lord, the law, I'll show, my lord, from the Reorganization Act, because of the policing being now with the center, my lord, tourism has started. Jammu and Kashmir traditionally didn't have much of big industries. They were cottage industries, small industries, etc. Main, Lord, the source of income was tourism. Now tourism has started. By now, Lord, 16 lakh tourists have come. New hotels are coming up, which gives employment generations for the two large number of people, right from Tangawala to Lord, officials. I'll come to that. So
In a manner of speaking, 35A is not a modification of Article 35. It is a creation of a new article in the Constitution. That's where I'll make this assertion.
The
It's
scope,
not a modification at all.
the scope of expression, exceptions and modifications
That's right.
will also.
So virtually you created a new article in the
A
Constitution.
new provision.
That's right. It's not a modification.
it's not a modification. Therefore, I respectfully urge 35A is creating a new provision in Constitution of India only to be applied to Jammu and Kashmir. Now, my lord, if a lady marries outside Jammu and Kashmir, she loses permanent residency. There are several such things, my lord. People coming from West Pakistan who were, my lord, settled down from decades were not.
The first part was struck down by a 3 judges bench of the J&K High Court.
By the High Court, my lord. I'm sorry, I was not aware of
But
it.
difference of view, 3 judges bench.
I'm told that children will not get. So whatever, my lord. That's now.
Others say children will not get it. It was a nebulous situation which we get.
Sheila Sami, right?
Now, my lord, kindly come to page 57. And my lord, the argument was that why did you not consult ABCD? My lord, out of ABCD, ABC is proclaiming that 370 is our right. Official, that's the official stand. So leave it at that. Please come to page 57. Now, my lord, use of mechanism under Article 367 for the interpretation of Article 370 for the first time. But any provision of the Constitution can be amended by executive action or constituent action, my lord. Now, without bringing the parliament. Therefore, my lord, 367 is a legitimate use so long as don't apply.
into the constitution as applicable to the state of Jammu and Kashmir
only.
by CA 48 of 1954.
Correct. So constitution was amended, which was 30, that was 370. You can amend the constitution or you can apply existing provisions.
Under
with-
370, a CO was issued, and which brought in a sense, 35. Right?
Correct. Now, my lord, page 57. Lord, as I pointed out, whenever the situation required it, 370 remained floating. Whenever some changes were required, depending upon the circumstances, they were made through the mechanism of 367. 367 is an interpretation clause. So the interpretation was made. Now, please come to page 57.
Yes.
Sub-article 4 was added in article 367 as applicable to Jammu and Kashmir. This sub-article 4 is not applicable elsewhere. It's only for Jammu and Kashmir. For the purpose of this constitution as it applies in relation to the state of Jammu and Kashmir, references to this constitution or to the provisions thereof shall be construed as references to the constitution or provisions thereof as applied in relation to the said state. Then references to the government of the state shall be construed as including references to the Sadri Riyasat acting on the advice of his council of ministers, because by that time Sadri Riyasat had come. References to a high court shall include references to the High Court of Jammu and Kashmir. D. Please note this, my lord. References to the legislature or the legislative assembly of the said state shall be construed as including references to the constituent assembly. They were used interchangeably.
That time there was no legislative assembly.
At that time, there was no legislative.
No, it was, my lord, to be made immediately. Therefore, my lord, in advance, my lord, they must have made a provision. There was none, my lord. This is 54, so there was none. Because the constitution was framed in 57.
So in terms of giving representation to the state in other forms, it would require Constituent Assembly to be interchangeably used so that till the Constituent Assembly finalize something, it would not.
No, my lord, another purpose is that till the legislature assembly comes, legislative assembly comes, somebody will have to make laws other than constitution. They were made. The Constituent Assembly after this functioned as a legislature of Jammu and Kashmir also. And they made other laws also. I have given the list.
It was primarily to ensure enforcement of 370 articles of clause 1, which power was vested with the legislative assembly. So they vested it with the constituent assembly.
Constituent Assembly, so that laws can be made by the Constituent Assembly. Otherwise, my lord, Constituent Assembly is not a law-making body in that sense. Of course, my submission is that Constitution of Jammu and Kashmir is at par with the legislation only. It's not, my lord, a kind of a constitution as we understand, my lord, as a document of governance. Comes to page 59. Look, these are the laws made. I'm not reading, it's not necessary. I'm sorry, my Lord Justice call is conferring. Lord, these are the laws which were made by the Constituent Assembly acting as a legislative assembly of Jammu and Kashmir. Page 59. Page 59, up to my lord, page 60. Lord, your lordships can consider noting here that exercise of mechanism under Article 367 to make changes in 370 is undertaken 4 times, which my lord, I'll come periodically. And whenever some body was not available, the successor body was named. Can I? I'm sorry.
Yes.
I'm sorry. I thought my lord, the Chief Justice is writing.
Yes.
But this exercise or use of mechanism under 367 was directly in issue in Damnu judgment.
Yes.
And it is approved by my lord, your lordships, my lord, speaking through the constitution bench. But then comes Puranlal Lakhanpal, my lord, I am not reading it because I don't think anything turns on that either for me or for the other side. It would not render any assistance. It just records the history, that's all, my lord, which we have, my lord, already given. Now, your lordships, my lord, kindly see page 62. The State Reorganization Act comes. It does 2 things. One, Part A and Part B states are clubbed into one called states. So Jammu and Kashmir ceased to be Part B, but it became a state like any other state. And Part C states became union territories. That is first. I'm sorry, C and D both became Andaman Nicobar was D. So A and B became states and C and D became union territories. We are not concerned with that right now in this matter. Second was the identity of princely states was completely abolished. Till then, till 56, the Raj Pramukh was the erstwhile princely ruler. This was abolished. That now, henceforth, it would be the governor appointed by the President of India. The President who is responsible to the Parliament and the Parliament who is responsible to we the people of India. So now, no Raj Pramukh, who is the princely state. He can be appointed as a governor, that's one thing. Some of them were appointed, but not by virtue of they being a member of that lineage in the princely states. But this happened. But at this stage, Article 238 was repealed. Rather omitted, not repealed, but it was omitted by 7th Constitutional Amendment. Your lordship,
Another thing.
Please come to page 63 only for one date which is relevant. I'm not reading anything.
Page?
Page 67, 63, 17/11/56, the constitution of the state of Jammu and Kashmir is framed. The document called Constitution of Jammu and Kashmir is framed. That's all. Thereafter, straightway, my lord, I have, my lord, given excerpts from the debates which essentially says that Jammu and Kashmir is an integral part of India. I don't think that is something which is my lord, required to be labored much. Therefore, I am not skipping.
Nobody raised that also.
Yes, my lord, therefore I am skipping that. Please come directly to page 67, my lords. The second use of the mechanism under Article 367. Your lordships would recall, in the first use, the Honorable President said Constituent Assembly and Legislative Assembly are used interchangeably. But at this stage, the Constituent Assembly ceased to exist because the constitution was framed. Therefore, please come to my lord page 67.
This is CO 56, right?
Yes, my lord. CO 56 dated 26th February 58. It was required in 58 because of a constitution of Jammu and Kashmir being framed and constituent assembly ceasing to exist, and because of the state reorganization act. Please see, my lord, at page 67 bottom, D is deleted. D read, reference to the legislature or the legislative assembly of the said state shall be construed as including reference to the constituent assembly of the said state. Because the constitution was framed, constituent assembly ceased to exist, and therefore, my lord, this clause was amended. And E, the term Raj Pramukh was replaced by the word governor because of the state reorganization act. Now, Raj Pramukh system has gone.
Yes.
Phraseology used was governor henceforth from this.
Yes, henceforth it was governor.
But the phraseology used to head of the elected government as prime minister did not cease with this.
I beg your lordship's pardon.
Chief minister used to be called the prime minister there.
Yeah, that went, my lord, after Sadr-e Riyasat itself. It became Sadr-e Riyasat. Prime Minister went.
Went after that. Only as a matter of sequence of dates I want.
Yes, yes. It became Sadr-e Riyasat, and thereafter, my lord, Raj Pramukh, and thereafter governor. Now it remains governor throughout thereafter. Now kindly see, my lord, page 69. I am skipping the rest, my lord. They are, my lord, Lord, kindly see, my lord, first page 68, Premnath call, but the first judgment,
Yes.
it was more on the competence of the Yuvraj. And therefore, my lord, I believe it may not render
Can we
assistance.
just read that para?
Yes,
Can we just read
I'll,
that
my lord,
para?
please. The Supreme Court renders its judgment in Premnath Kaul versus State of Jammu and Kashmir. It's a 5-judge bench, my lord. The issue before the court was the validity of Jammu and Kashmir Big Landed Estate Abolition Act, which was enacted by the Yuvraj in exercise of powers vested in him under Section 5 of Jammu and Kashmir Constitution Act, 1996. Well, 1996 is somewhat year, 1939, the old constitution. The judgment discusses the constitutional history of the state in great detail and at the same time discusses the power of Maharaja under the previous constitution of the princely state. The question before the court was whether the provision of Article 370, sub-Article 1 till the time the Constituent Assembly of Jammu and Kashmir was in session affect the plenary powers of Maharaja in the matter of governance of the state. In this context, the court held that the act in question, which was enacted in 1950, would not stand interdicted by Article 370 and held that Yuvraj was competent to enact the act. The case effectively concerned the issue of legislative competence of Yuvraj when there is no Constituent Assembly of Jammu and Kashmir. Yes. But in these very proceedings, when there was a request for a reference to a larger bench, in this very petition, Lord, the 5-judge bench, Lord, speaking through my Lord Justice Call, exactly said this, that it may not have bearing on the either side. Now, Lord, page 69. Now, my lord, the integration of judiciary. Slowly, my lord, some provisions came to be applied, truncated, some full